be difficult to argue one by one.
I agree.
Both at a time.
Malas, posterity will also get to know what foolish arguments we made, Malas.
And also good arguments, of course.
But
And
nobody
of course,
admits.
good argument.
Nobody admits.
But it's we will, of course, this will be a great record for the
No, no,
court.
Yes, yes.
It will-
No, I think it's a wonderful idea.
Truly a court of record.
Yes.
Because every word is recorded.
It should be. It should be.
Every word is recorded.
Court of record.
Malas, in fact, I can share something with you. When Malas practicing in New York, we have these EBT proceedings, that is examination before trial. And I'm talking about this, about the 70s. Malas, they would record everything that was said in the course of
Yes.
that examination, even then, so that we know, lawyers knew what was going to happen.
Gujarat has e-court, not in the sessions division, sessions courts, where even our internal whisperings are also recorded.
That's very dangerous.
Do you agree?
That's hazardous, completely hazardous.
Now, the only thing is that if there are two or more voices at the same time,
Yes.
that causes a little bit of a problem. But they obviously have personnel who will clean up the errors by the evening. They suggested that during the course of the day, the council will get the link, so the council can look at it. By the evening, they would have cleaned up the entire transcript and given it to us. So
That's wonderful. That's wonderful. That's truly
In VC
Truly
proceedings,
a milestone, I would say, Malas.
in VC proceedings, anybody wanted to interrupt would lift their finger. So much there is no crosstalk.
That's
So
right.
we can follow that so that it won't
Hopefully.
overlap with one another.
So, Malas, let me just give your lordships a broadside view, Malas, of what is in issue here. Then I'll go on to the matter in some detail. Malas, as your lordship knows, Malas,
pen drive last time ka. Yes,
what is in issue is whether
last time ka.
the legislative party, that's the central issue, whether the legislative party in the House acts independently of the political party. That's the central issue. Because I will, Malas, while I go through the facts before your lordships, indicate to your lordships that on the 21st of June, when the first meeting took place, and we called, the group led by Uddhav Thackeray called members of the legislative party who belonged to now the Eknath Shinde group to come and attend the meeting, which was not done, pursuant to which some actions were taken. The contention throughout has been that there is a split in the party. So the issue before your lordships is, can members of the legislature within the House or comprising of those members of the House by themselves say that there is a split in the party because they don't agree with the leadership? This in turn would require your lordships to look at the 10th schedule and in that context interpret the role of the party within the legislature. Because after all, members of the legislature of any particular party get elected on a symbol of the party. They are there because of the party. And if they are there because of the party, Malats, there is an umbilical cord link between them while they are sitting in the House and the party outside. Can that link be severed and say, we are an independent set of people, we can do what we like? That will require, Malats, the interpretation of the 10th schedule. It requires your lordships to analyze the role of the whip, how a whip gets appointed, how he happens to be a bridge between the legislative party and the political party. And that nothing happens in the House without the political party taking a decision. Nothing happens. Mullah, the bill is introduced by the Treasury benches, any bill.
So
What
is it
happened?
your contention, therefore, Mr. Sybil, therefore, that unless there is a split outside the House,
Yes,
within the political party,
yes.
that split cannot find recognition within the legislative party within the House? That's your...
Absolutely. That's my contention.
It could
That's the law also, Mullah, and I'll demonstrate that to your lordship. That is the law. Well, what happens, Mullah, I'm giving your lordships an example, Mullah. A bill is introduced by the Treasury benches, a controversial bill, let's assume. Bill there in which there is no consensus. Mullah, what happens? The parliamentary party, a group of members of the legislature are invited by the parliamentary party to sit outside the House in a particular room and say, this is the bill that's being introduced. What should be our position? The party decides the position. And it's articulated in the House. The legislative party by itself, dehors the party, doesn't decide what we are going to do, what you are not going to do. When a whip is going to be issued, Mullah, it's issued outside the House, translated inside the House. Okay, on this, you're going to vote against the bill that has been introduced, or that you will vote in favor, or that you will abstain.
But when the 10th schedule speaks about, say, a merger, for instance, now,
Yes.
there are very few exceptions in the 10th schedule, and it speaks of a merger.
Yes.
Ultimately, the speaker has to decide whether there is a merger. The speaker will not go into whether there was a merger outside the House, because then the speaker will be taking over the function of the Election Commission of India.
That argument is entirely on a different plane, Mullah. So we're not dealing with it, and we'll interpret the paragraph 4 for your lordships also.
The speaker's remit cannot lie outside the House.
Mullah, there's a problem. Supposing, all right, then let's analyze that for a minute, Mullah, since your lordships have raised the issue. Mullah, supposing there are 10 members of the legislative party in the House, right? And the merger has to take place of the political party. They belong, say, to the Mullahs, to the Samajwadi party, right, Mullahs? Now, even paragraph 4 says that there's a merger of the political party, not the merger of the legislative party.
Right.
Right? So therefore, Samajwadi party has to merge.
But no, if we accept your argument, that would mean that unless the Election Commission of India decides on a merger outside the House, the speaker cannot take a decision within the House, within
No,
his
Election
constitutional
Commission
remit
did not
on whether
decide.
there is a merger or not. That can't be.
No, Election Commission did not decide this issue, Mullahs.
How else?
Because a resolution will be passed that we have merged. And that will be informed. The Election Commission, they don't have to take a decision. They'll be informed. Majority of the members of the party will decide. They'll be informed. Once merger takes place, these eight people may say, we don't want to merge. And paragraph 4 says they need not merge. But I'll come to that later. This is a very complex issue.
Actually,
Not so.
Let's have a broad now framework of the facts, because
I will, Mullah.
in fact, that was our basic problem there. Unless we have a clear perception on the
I'm going
facts,
to
it's
do
very difficult for us then to look at the law divorced from the facts.
I entirely agree, but just, Mullah, may I just, your lordship, what are the issues that are going to be? I just told your
that's
lordships too.
we have to necessarily reframe the issues, huh? Because the issues which are there, which are
Yeah, it's not reflective of, Mullah, what needs to be decided. I agree entirely. Mullah, the other issue is, and that's never come up before the court. And that issue is, can a governor swear in a member of a legislative party against whom a disqualification matter is pending before the House? That's the other issue. Never come up before. What then are the powers of the governor in matters in relation to disqualification? This is not a case of a pre-poll alliance. This is not a case of a post-poll alliance. This is not a case of one political party. It is a case of people who allege that they are the party because they are a majority in the legislature. Right, Mullahs? What then are the powers, or what should be the function of the governor in matters of this nature, and how he should conduct himself? Because he also knows, because the disqualification petition is pending, Mullahs. He also knows it. And if the governor does, Mullahs, swear him in as a chief minister, Mullahs, he actually topples a democratically elected government and aids in doing that because they happen to be majority in the legislature. Well, that's one of the issues that your lordships may have to consider. Then the other issue to be considered is, can a court, constitutional court, without referring the matter to the speaker in the facts and circumstances of this case, decide the matter on its own, given the fact that there are no disputed facts? We are not going to, Mullahs, place before your lordships any disputed fact. All are matters of record.
Your question is, can a constitutional court decide 10 schedule?
That's correct.
10 schedule.
Yes, that's correct. That's correct. That's correct. Because under the 10th schedule, it is the speaker to decide, Mullahs. Correct, Mullahs? But if the proceedings, Mullahs, are imbued with illegality, and given the conduct of speakers in the past, what then should be the attitude of the court in a given matter? That's the other thing. And then, of course, lastly, Mullahs, how do you deal with an issue? And that, Mullahs, because the last question in the reference is the powers of the Election Commission. And your lordships, and that's the last question, which is the last issue your lordships will have to decide, that under paragraph 15 of the symbols order, when there is a split in the political party, it starts with that proposition that two factions have arisen pursuant to a split in the political party. Then which faction should get the symbol?
Will that arise in this case?
I'm sorry?
Will that arise here?
Yes, that's a question. That's a question. What is the role of the Election Commission in matters under the... That's part of the reference.
So under paragraph 15 of the symbols order, when two factions emerge in pursuance of a split.
Yes.
So what is the sequitur? How would you end the sentence?
Well, then what is the role of the Election Commission in deciding that matter? Should it await the decision of the Constitutional Court? Should it go ahead? Your lordships only, Mullahs, as your lordships will remember, in September said no stay. But your lordship did not say how he is going to decide it.
But that, Mr. Sibel, is your independent challenge to the order of the Election Commission.
That's a separate issue, Mullahs.
We can't really decide.
No, that's part of the reference, Mullahs. I'm going to argue, Mullahs.
Can we, how do we...
He's saying
constitutionally, the Election Commission cannot proceed. Mullahs, the split would have to happen on 21st of June. There was no whisper of a split on 21st of
Your
June.
contention that therefore the Election Commission itself cannot proceed until the Speaker has decided.
Correct. That's what your lordship said. No stay, fine, Mullahs, no stay. We went before the Election Commission and said, you cannot decide this matter. The matter is pending in Supreme Court. He said, no, but Supreme Court said no stay. And you will find that tomorrow, Mullahs, when your lordship sit at 3:30. But be that as it may, that's the last question that your lordships, your ladyship will have to look at. So these broadly, Mullahs, are the issues that you might be asked upon to decide, Mullahs, that you might wish to decide. Now, Malaj, let's go to the list of dates, because unless you have the facts, Malaj, it'll be. Malaj, this is now PDF page 108 of the written submissions. It is marked as capital A, and I have learned how to use the iPad.
Mr. Sybil, just wondering if you could just look at the issues that were framed,
Ladyship, I can't hear you.
look at the issues that were framed once so that we know the perspective in which you're arguing, the issues that were framed for reference to the Constitution.
I can read those.
Can we just to review?
Yeah, I think it's a good idea.
Call before we
Reference
proceed
order.
further.
Yes, reference order. Your lordships will have that. Order compilation, Malaj. PDF page 28.
Order compilation.
Orders compilation, PDF page 28. And the questions start at page 30.
What is the order dated?
It is on order dated, Malaj, 23rd of August, 2022.
Page 28.
Page 28, Malaj, and the relevant part, the question starts at page 30 at the bottom.
Order compilation, right.
28.
PDF page 30, Malaj.
28.
Your ladyship has it? Justice Shah, Malaj?
Yes.
May I, Malaj? A, whether notice for removal of a speaker restricts him from continuing with disqualification proceedings under the 10th schedule of the Constitution as held by this court in Nabia. Malaj, I've already argued that. So lordships, Malaj, have deferred your lordship's judgment on that. So we'll skip that for the moment. B, whether a petition under Article 226 or 32 lies inviting a decision on a disqualification petition by the High Court or the Supreme Court, as the case may be. That's the question that I have already formulated in different, the language is somewhat different, but the intent is the same. Then C, can a court hold that a member is deemed to be disqualified by virtue of his or her actions absent a decision to the speaker? Actually, B and C are together, Malaj. They are interlinked.
Per se cases.
Yes. The language is somewhat, Malaj. D, Malaj, what is the status of proceedings in the House during the pendency of disqualification petitions against the members? Malaj, it really doesn't clarify what it means. What is the status of proceedings? What it means is that can members against whom there is a disqualification petition pending have a role to play in the House while it is pending? Otherwise, you can topple any government you want. Then E, Malaj, if the decision of a speaker that a member has incurred disqualification under the 10th schedule relates back to the date of the action complained of, then what is the status of proceedings that took place during the pendency of a disqualification petition? Now, Malaj, this question only arises if you allow proceedings to go on. If you don't decide on the disqualification before, then this question arises, because if at a later point in time, you consider them to be disqualified relating back to the date when their act led to a voluntary giving up membership of the party or violation of the whip, then, Malaj, what happens to the intervening proceedings? A government has been formed, actions have been taken, policy decisions have been made. Would it not be better, for the purposes of, I personally believe, democratic traditions, that you should await your hands till the disqualification is decided. First, because this problem will not arise then. Then, my lords, F, I think, is very, very important. What is the impact of the removal of paragraph 3 in the 10th schedule? According to me, that's central to the entire issue. Because now you don't have a split. The issue of a split doesn't arise. Which is why, if you want to go to the election commission, there has to be a split in the party, not a split in the legislature. That is not on record. No such split. So this is central, and we'll interpret paragraph 4 also in that context. Then G, what is the scope of the power of the Speaker to determine the whip and the leader of the House legislative power? What is the interplay of the same with respect to the provisions of the 10th schedule? Well, it's actually, again, convoluted in its expression. In simple terms, it means that how is a whip appointed and how is a leader in the House appointed? Is it a role of a political party, or is it something that the legislative party decides? Can majority of the legislative party members decide, I'll change the whip tomorrow? Can't be. So what has happened in this case, and I'll come to the facts, Mullahs, that sitting outside the House, X number of people said, you are no longer the whip. And those are members of the legislature only. Mullahs, I can give your lordship's documents to the effect. What happens is when a leader of the House is appointed, the letter that is given to the Speaker is that the party hereby decides that this person will lead the House for the party. It's not the members of the legislature don't decide these issues. Similarly, whip. Because the whip is the bridge between the government, or the opposition, whichever party it is, and the House, members of the legislature. That's why your lordships will see that nowhere in the Constitution does the word political party is referred to, except in the 10th schedule. Because in the Constitution, you're dealing with institutions. You're dealing with an institutional framework within which all political parties function. In the 10th schedule, you're dealing with framework within which a legislative party functions in the context of the political party, resulting in disqualification. Then, Mullahs, H. Are intra-party decisions amenable to judicial review? I don't think that question arises. There's no intra-party decision in the legislature. So your ladyship is right that we need to look at some of these questions. Then I, what is the extent of discretion and power of the governor to invite a person to form the government and whether the same is amenable to judicial review? Well, it's governor's actions are always amenable to judicial review. That's not an issue at all. Question is, what should a governor do in the context of disqualification petitions pending and which are yet to be adjudicated upon? As a governor, Mullahs, who he is a constitutional authority, he needs to protect the constitution and the laws. In this very state, a governor, Mullahs, in the early hours of the morning, gave an oath, to the oath of office, Mullahs, made somebody a chief minister, and by the early morning, Mullahs, on daylight, he had to resign. governors, and I say this with respect to all the institution of the governor, that governors have, in my respectful submission, acted far beyond their constitutional responsibilities, as we have seen, as I have seen in the recent past. That may not be a proposition that the other side will accept, but I'm giving only my view of the matter. It is unfortunate that governments are actively involved in the politics of the country. Then, Malas, the last one. What is the scope and the powers of the Election Commission of India with respect to determination of a split within a party? That's where, Malas, the question of para 15 of the symbols order comes in. Let's kindly now come to the written submissions of the petitioner. And the list of dates is at page 108. PDF 108.
That is A, right? A, petitioner written submission.
10, yes, A. PDF 108.
Written submissions of the petition.
Written submissions, no?
Yes,
You are referring to written?
yes.
Not additional written submissions. Not additional written submissions.
A, Manas, A.
A.
Page 108, PDF.
Mr. Sibal, what we could also do is that, of course, we've seen the broad points of reference, but ultimately we'll need to narrow down the reference to the issues which you want to focus on.
Yes.
And maybe if you could, during the course of the afternoon, share that with the other side. We can have their feedback so that we narrow it down to certain specific issues. Because many of the issues which have been framed in the reference order may not strictly arise.
Yeah, it's not necessary. I
So
said that
let's
already.
sort of structure that so that it lends some clarity to.
Well,
submissions to
let us do that in the evening. Well, that would be much easier for us. Because
difficulty.
if your lordships will allow us, because I'll consult my colleagues.
Yes, absolutely.
We'll
Also,
give some
you can
agreed
sit down,
issues, Malad,
in
yes.
the evening and give us some agreed issues which will arise.
Because afternoon may not be the most appropriate.
Evening would be fine.
Yes, we will.
And also then we can have some idea about, the time schedule, how long would you take, so that then we can so restrict them as well and to certain time.
Malad, this side, Malad, will take 3 days, Malad.
Mr. Sibal, how long would you take? About 3 hours or so today?
No, Malad, I'll take much more tomorrow too.
Mr. Sibal, we'll have to have structured arguments.
All right, it'll be structured, Malad. I'm not going to repeat myself at all. Your lordship knows I myself, Malad, reduced,
After Mr. Sibal, after you conclude, Dr. Singhvi will
Dr. Singhvi and then Mr. Kamath, my colleague, Mr.
So
Kamath.
why don't, maybe we could do this. We have about an hour and 15 minutes before lunch, and you get 2 hours after lunch today. That's about 3 hours and 15 minutes. So maybe if you could conclude today by 4 o'clock, then we can give Dr. Singhvi until lunch tomorrow.
Yes.
And then a little supplement to half an hour after lunch for Mr. Kamath.
Yes.
And then they can start tomorrow afternoon. We are breaking at 3:30 tomorrow. So they get about an hour and a half in the afternoon. And maybe on Thursday, they can conclude by maybe lunch. And then we give you.
We'll try that, Manoj. We'll try that. No issue, Manoj. We'll certainly try and speed it up. I mean, I just think, Manoj, your lordships may have questions yourselves.
No, of course. If we find that, of course, there's a little change in the time schedule, we can certainly do.
Then, Manoj, your lordships will also have to decide on the Nabam reference at some stage, what your lordship wants to do, because
Yes.
that sort of opens up another.
So we'll look at the list of dates.
Yes, Manoj. So on 1966, Shivsena, founded by Barasaheb Thackeray, to espouse the ideology and legacy of whatever, and has been recognized as a state political party by the Election Commission. Barasaheb Thackeray was the president, Shivsena Pramukh of the Shivsena from its very inception and continued in the role till his demise on 17th November 2012. After the demise of Barasaheb Thackeray, Uddhav Thackeray was unanimously elected to be president, Shivsena Paksh Pramukh of the Shivsena political party, and has continued to hold the position. At present, Shri Uddhav Thackeray unequivocally continues to be the Paksh Pramukh of the Shivsena, president of Shivsena, which is the highest position, as provided in the constitution of Shivsena. Copy of the constitution is annexed. 85, in view of the repeated defections of elected MLAs, MPs, and with a view to curb horse trading of an elected representative, the constitution was amended to include the 10th schedule by virtue of the 52nd Amendment to the Constitution with the following statements and objects. The evil of political defections has been a matter of national concern. If it is not combated, it is likely to undermine the very foundation of our democracy and the principles which sustain it. With this object, an assurance was given in the address by the President to Parliament that the government intended to introduce in the current session of Parliament an anti-defection bill. This bill is meant for outlawing defection and fulfilling the above assurance. So nothing in the 10th schedule should be interpreted to give credence to a defection. Nothing in the 10th schedule should be interpreted to somehow legalize a defection. Give credibility to that process, because the whole object of the act is to ensure that there are no unprincipled defections. Well, if there is an elected government, the attempt of the court and of the institution of the governor should be to allow the elected government to function till such time as a person is either disqualified or not disqualified. Right? And if there is a disqualification petition, that should be allowed to be decided. Because if you don't allow that to happen and you pass an order like you did on the 27th of June, unfortunately, it's the judicial order that led to this. It is that judicial order that led to this. Had that not been passed, we wouldn't be here. And if the speaker had been allowed to decide, and they would have gone up in appeal if there was a decision against them, or somebody else would have gone up in appeal. Yes. So, 7th of April, the 10th schedule was amended by the 92nd Amendment, and paragraph 3 thereof, which permitted 1/3 members of the legislative party to split, was omitted. Split is no longer available as a defense against disqualification under the 10th schedule. Please mark that. The defenses available were only two. That I have 1/3 of the legislative party has split, pursuant to a split in the political party. It is not a split of the legislative party. Paragraph 3, and I'll read that, your lordships, it is a split in the political party, resulting in 1/3 of the members in the legislative party, which gives them a defense to say that they cannot be disqualified. Similarly with paragraph 4, it's a defense. If I am 2/3 and there's a merger of the party, it's a defense saying, now I am entitled to be that party. That is part of the new party. Either a new original party or part of the merged party. That's a defense. That's why I indicated to your lordships, now there's no question of majority, minority, 1/3, 2/3, not relevant. If there's a split, Because what? The purpose of the defection law is to ensure that there is no unprincipled defection. Then, Malads, 23rd of January, organizational elections of the Shivsena political party for term 2018 to 23 were held, wherein Uddhav Thackeray was elected as president. The results were duly communicated in the prescribed format to the Election Commission on 27th of February 2018. Well, the Election Commission, and that, Your Lordship, is not relevant here. Election Commission in its order says, I don't have your constitution. Therefore, I will not consider that you are about the organizational wing structure. I will not consider it all. So I go only by what is the legislative majority, and the legislative majority is 38 people from Eknath Shinde group, therefore they get the symbol. Anyway, that's another matter. Then, Malads, October 2019 elections in the 14th Legislative Assembly of Maharashtra were held. The seat distribution in the said election inter se of political parties is following. Your Lordship knows this. You have seen it before. Then, Malads, November 2019, a post-poll alliance was formed between the Shivsena, the NCP, as well as the INC called Maha Vikas Agadi to form a stable government in the state of Maharashtra, with the president of Shivsena, Uddhav Thackeray, being sworn in as the chief minister. 23/11/2019, prior to the swearing in of Thackeray, the governor hastily sworn in Devendra Fadnavis early in the morning as the chief minister of Maharashtra. This honorable court in Shivsena versus Union of India directed an immediate floor test, and Devendra Fadnavis resigned before facing the floor of the House. This only indicates how governors, Mullahs, have been conducting themselves. How can a governor have sworn in somebody as the chief minister without knowing that he has majority in early hours of the morning?
This order is on 23rd November,
Yes,
Supreme Court's order.
yes. Oh, the order, I just... 2019, 10 SCC 809.
Tell me later.
Yes. Then it's mentioned. Anyway, April, May 2020, governor has been at loggerheads with the 2511. Oh, 2511, Sunil Prabhu. Now, this is important. 2511, Sunil Prabhu is appointed as chief whip of the Shivsena Legislative Party with the blessings of Uddhav Thackeray, president of the Shivsena political party, and the same was duly notified to the Speaker of the Maharashtra Legislative Assembly. Well, that, Your Lordship, may actually, if Your Lordship don't mind, look at that document. Or do you want to read the dates and then later?
Please read the entire dates.
All right. Then April, May 2020, the Honorable Governor has been at loggerheads with the MVA government and has almost created a political crisis. Governor was sitting on Shri Uddhav Thackre's recommendation for nomination to the Maharashtra Legislative Assembly, despite a period of 6 months as an unelected member was about to expire on 27/5/2020. Further, the governor had blocked holding of the speaker's election. No speaker's election took place. Well, he was not a member of, there was a seat, for in the Legislative Council, which had to be, he had to be elected from that seat. He wouldn't hold the election for almost 6 months. This tells you, how constitutional authorities are acting. First you swear in somebody, he resigns the next morning, or then you have this problem. The BJP has been attempting to create divisions within the Shivsena, 20th June 2020, in the recently conducted MLC election, wherein despite having the requisite number of MLAs on its side, the MVA alliance led by Shivsena lost a seat to the BJP. This was because of cross-voting within the MVA and particularly within the Shivsena at the behest of the BJP. I'm not going to rely on these facts, because this is disputed. So that these facts I'm not going to rely on. It was widely reported in the media that Eknath Shinde, who was then the Cabinet Minister of Urban Development and Public Works, has, along with certain others delinquent MLAs of the Shivsena, gone into hiding in the BJP-ruled neighboring state of Gujarat. Then 21(6), these are the undisputed facts that now start. To contain and allay the apprehensions that were arising in the party post the MLC elections, an urgent meeting of the Shivsena Legislative Party was called on the 21st of June. Eknath Shinde, along with certain other delinquent MLAs, did not attend the above-mentioned meeting, dated 21st of June. The party resolved in the said meeting to remove Eknath Shinde from the position of the leader of the Shivsena Legislative Party and appoint Ajay Chaudhary instead. Now, this is interesting because this is a matter which your lordships have to constitutionally consider. So a faction, which is the legislative party, decides that I will change the whip. Constitutionally impermissible. Then, Millets, the decision, then Millets, Eknath Shinde, along with certain other delinquent MLAs, did not attend the meeting. Party resolved in the said meeting to remove Eknath Shinde from the position of leader of Shivsena and appoint Shri Ajay Chaudhary instead. The decision to remove Eknath Shinde was communicated by Uddhav Thackeray to the Honorable Deputy Speaker. After due verification, the Deputy Speaker accepted the change of leadership of Shivsena in the House. The reason why this happened was, Millers, because, as your Lordship knows, he had to be a member of the Legislative Council because there was no seat in the Assembly. So the then Chief Minister became a member of the Legislative Council. Therefore, Millers, in the meantime, somebody had to be appointed, Millers, as the leader of the House because they were the Treasury benches. So Eknath Shinde was the leader of the House. And he was removed from his position of leadership by a decision of the party. And the Deputy Speaker was told about it and he accepted it. In the larger interest of the party, it was thought fit to call for another legislative party meeting to give one more opportunity to the MLAs who were absent in the meeting on 21st June to show their loyalty and support to the original political party. Hence, another meeting of the SSLP was called. Individual notices were issued to all the MLAs of the Shivsena, and it was made adequately clear that, quote, failure to participate in the meeting without providing valid and adequate reasons in writing, communicated in advance to the underside, will result in consequential action against you under the relevant provisions of the Constitution. So they were told. On 22nd of June, despite the importance of the meeting called on 22nd June, aimed at consolidating the SSLP's strength to contain any possible horse trading, several dissident MLAs did not attend the meeting. Instead, the delinquent MLAs sitting in BJP-ruled states sent communications rejecting the holding of the meeting as illegal, which itself shows that those MLAs had been working contrary to the diktats of the original political party. 22nd of June, Sunil Prabhu, in the capacity of Chief Whip, responded to the communication dated 22nd of June of the delinquent MLAs rejecting the reasons given for their absence from the SSLP meeting as an afterthought, frivolous, backdated, and proof of them acting contrary to the interests of the original political party. That's the notice that your lordships read, 21st of June, dated 21st of June, received on 22nd of June at 11:30 a.m., but dated 21st June. Eknath Shinde wrote to the Deputy Speaker communicating his appointment as leader. So now, Millers, the legislative party or a majority of the legislative party can decide who they're going to be the leader of the party in the House, of the party, sitting in Assam. On 22nd of June, simultaneously, a purported notice for removal of Deputy Speaker Narhari Zirwal under Rule 11 of the Maharashtra Assembly Rules, read with 179, was received at the Legislature Secretariat, expressing no confidence in the Deputy Speaker. Notice was hand-delivered by an unknown courier and not by any MLA. It is also relevant to note that none of the purported signatories of the notice had personally delivered any such notice, nor it was sent through the registered email address of any of them. The Shivsena Legislative Party in its meeting took note of Shri Eknath Shinde and rebel MLAs and the fact that they had indulged in anti-party activities and were trying to destabilize the MBA government. In view of this, it was resolved that the Shivsena Legislative Party meeting at the then CM's residence, that necessary legal action shall be taken under the 10th schedule against the errant MLAs. Now, who is CM Malaj is a member of the Legislative Council. He is also the Param Pramukh, Paksh Pramukh. So he is the political leader. He is the one who decides. June 23rd, Sir Sunil Prabhu filed disqualification petitions under Para 21A, seeking disqualification of Eknath Shinde and 15 other delinquent MLAs of Shivsena. 24th of June, it was widely published in the news reports that the rebel MLAs led by Eknath Shinde were acting in collusion with BJP, and their entire logistical arrangement in Guwahati was made by the BJP leaders. 24th of June, Secretary of Maharashtra Legislative Assembly received an email from an advocate named Vishal Acharya attaching notice for removal of the Speaker dated 21st of June. On the same day, the Secretary of the Assembly communicated the decision of the Deputy Speaker to the email of Vishal Acharya, refusing to take on record the communication dated 22nd of June until the genuineness and veracity of any such communication and its signatories was ascertained. 25th of June, one of the dissident MLAs, Deepak Kesarkar, in a live interview declared that the dissident MLAs had formed a new group and named it Shivsena Balasaheb, and had also announced that they will have a separate leader whip, office, and everything else, just like a party has. 25th of June, Honorable Speaker, after due verification, was pleased to issue notices to the delinquent MLAs under Rule 6 of the Maharashtra Legislative Assembly Disqualification on Ground of Defection Rules 86, read with the 10th schedule of the Constitution, asking the delinquent MLAs to file their replies by 5:30 on the 27th of June, 2022. On 25th of June, the National Executive Meeting of the Shivsena was held. The said meeting was attended by over 163 representatives of the National Executive, and the leadership of Uddhav Thackeray as the President of Shivsena was unanimously and equivocally accepted by the National Executive. 25th of June, Sunil Prabhu filed an additional affidavit in the disqualification proceedings inter alia, containing the media reports that showed the hobnobbing of the delinquent MLAs with BJP leaders. 25th of June, Sunil Prabhu filed disqualification petitions against 2 independent MLAs and 1 MLA belonging to the Prahar Jan Shakti Party. The petition against the independent MLAs were filed on the ground that they gave up their independent status by taking part in the resolution dated 21st of June, passed by the rebel MLAs, and signing the said resolution on the letterhead of SSLP. Also, the ground taken against BJP MLA was that the said MLA voluntarily gave up membership of his original political party by taking part in the said resolution dated 21st June and by signing the same on the SSLP letterhead. 27 June, issuance of the notice of 25th June by the Honorable Deputy Speaker came to be challenged by the 16 MLAs, including Shri Eknath Shinde, who filed a writ petition under 32. The said court, the Honorable Court, by the interim order dated so-and-so, in writ petition so-and-so, was pleased to, in the interim, direct this. Thus, meanwhile, as an interim measure, the time granted by the Deputy Speaker of the Assembly to the petitioners or other similarly placed members of the legislative party to submit their written submissions up to today, today 5:30 p.m. is extended till 12/7. Well, just kindly note the language here, as an interim measure. They have not filed a reply till date. We are now in February 2023. They have not filed a reply. Now, Malaj, prior to this, prior to the passing of this judicial order, Malaj, all that happened was happening outside of Bombay, outside of Maharashtra, in a state in the northeast. And by whom? By these members of the Legislative Assembly, that's all. There was no party in sight. There was no meeting of any party. Nobody called for a meeting of the party. And these are undisputed facts, Malaj. These are not disputed facts. Can the 10th schedule countenance a situation where, because of whatever reasons, Malaj, we don't want to go into it, a majority or even a minority of MLAs are just, Malaj, let's forget the majority. Supposing a minority. You don't sometimes need the majority to topple a government. You'd only need a minority. Supposing it's a minority, and the minority outside the state of Maharashtra says, I have formed. I am the political party. And then a judicial order is passed on a disqualification petition. Then no. If a petition is filed, you can file your reply after 10-15 days. In the meantime, the minority gets in touch with the other party, topples the government, a new chief minister is appointed. Can you ever imagine that the 10th schedule would allow that? Can it ever be countenanced? This is harakiri. This is legislative harakiri. Political harakiri. And you can't interpret the 10th schedule, in this particular fashion to allow an elected government to fall. That's why I said it is judicial orders of this court that resulted in this. Then, 27th of June, as several other members of the SSLP had also openly indulged in anti-party activity. Now, can anybody say, that this is not anti-party or this is not giving up membership of the party? One of you sitting there say that we are forming a new party called Shivsena Balasab. And you are sitting in a state ruled by the opposite, ruled by a party, which was in the opposition. First you go to Gujarat, then you go to Assam. There is no dispute on that. These actions per se amount to giving up membership of the party, apart from the fact that you don't attend the meeting on 21st, 22nd of June. So what is the speaker going to decide? What can he decide? Given these facts. Then 28th of June, late in the evening, the leader of opposition in the state of Maharashtra, Devendra Fadnavis, went to meet the governor and requested him to hold a floor test after the stay. That's where the role of the governor comes in. On 28th of June, immediately after meeting Devendra Fadnavis and with utmost haste, the governor sent a communication dated 28th of June, though received in the early hours of 29th of June to the then Chief Minister, directing him to face a floor test in the House on the very next day, 30th of June. It is relevant to note that the Honorable Governor did not even attempt to ascertain from the Chief Minister whether he enjoyed the majority of the House. On 28th of June, the Governor, by way of a separate communication dated 28th of June, which was received in the early hours, directed the latter to forthwith on 30th June to convene the Assembly and hold a floor test. 29th of June, Sunil Prabhu filed a writ petition before this Honorable Court seeking a stay. So, we said, please stay the matter. Please don't allow this to happen. Of the directions of the floor test in view of the fact that the disqualification petition of 42 MLAs under the 10th schedule are pending. By order dated 29th of June, in writ petition so-and-so, this court was pleased to direct as follows. Having given a thoughtful consideration to the rival submissions, we do not find any ground to stay convening of the special session of the Maharashtra Assembly. How? Vidhan Sabha on 30th June, tomorrow at 11 a.m. and with the only agenda of a trust vote. So therefore, you give legitimacy to those against whom disqualification petitions are pending, and such legitimacy that they are able to topple the government by colluding with another party, which is in opposition in that very state. That's the effect of the judicial order. So first, stay the proceeding before the Deputy Speaker, then allow this collusion and get an elected government toppled. What used to be the misuse of 357 has now been substituted by the misuse of the 10th schedule. 356 was now misuse of the 10th schedule. And the proceeding of the trust vote to be convened on 30th of June shall be subject to the final outcome of the instant petition. That's another interesting thing, brothers. Proceeding of the trust vote shall be subject to the final outcome of the instant petition as well as the writ petitions referred to above. So therefore, Malaj, every action of the governor resulting in a new government having been formed is subject to your lordship's decision in these petitions. So you cannot give it the color and clothe it with legality, because the judicial order itself says that it's subject to. So you cannot say now the trust vote has happened, now a chief minister has been installed, now a government is in place, now you can't do a thing about it. The special session of Maharashtra Vidhan Sabha shall be conducted in accordance with the directions that contained in the communication dated through 28th of June of the Governor of Maharashtra. Then 29 June, Chief Minister Uddhav Thackeray resigned. Because he knows the writing was on the wall, having given legitimacy to those who... Then 30th of June at around 3 p.m., Eknath Shinde and Devendra Fadnavis met the governor and staked claim to form the government. This is also anti-party activity. No evidence is required on this. Then 30th of June, the governor, without taking into account the fact that the membership of Eknath Shinde itself was in dispute, here again the question of the governor comes in, in dispute. In the imminent disqualification petition pending against him, swore Shri Eknath Shinde in as the chief minister and Devendra Fadnavis as the deputy chief minister of Maharashtra. The honorable governor thereafter directed Eknath Shinde to prove his majority on the floor of the house. We knew that everybody knows that he would have the majority thus. You can fool the constitution, but not the arithmetic. Then the governor, without taking into account the fact that the members, and I've read that. Then 30th of June, due to their anti-party activities which unquestionably amounted to relinquishing membership of the Shivsena political party, Shri Shinde, Tanaji Sawant, Uday Samant, and Gulab Rao Patil were removed from their positions in the organizational setup of the party by the undisputed president of the Shivsena, Shri Uddhav. Well, let's just note here, no meeting of any political party took place at the instance of Eknath Shinde. And you will see that tomorrow in the petition before the Election Commission. That alleged meeting, which I'll show is bogus, happened to have taken place on 18th July, after all this was over. And the petition for getting the symbol was filed on the 19th July, on the very next day. Then, Malaj, one second. Yeah, I'll take it. Then, Malaj, 1st of July, 2022, Shivsena Secretary sent a letter to the Election Commission intimating the authority regarding the removal of Eknath Shinde from the positions of Shivsena and change in the organizational setup of Shivsena thereto. Also, by the separate letter, the Shivsena Secretary intimated the ECI regarding the removal of Tanaji Sawant and Uday Samant from the organizational position of Shivsena. Similarly, the Shivsena Secretary sent another letter to the Election Commission of India intimating the authority regarding the removal of Gulab Rao Patil from the organizational position of Shivsena. On 1st of July, an application for directions, IA such and such, was filed by Sunil Prabhu in the present writ petition seeking an interim order suspending the delinquent MLAs against whom disqualification petitions have been filed till the final adjudication of the 10th scheduled proceedings. The said application was mentioned before this court for urgent interim listing, wherein this honorable court directed to list the application along with the writ petition on 11th of July. Then 2nd of July, the Principal Secretary, Maharashtra Legislative Assembly, circulated working order for conducting election to the office of Speaker on 3rd of July. The said agenda showed that the name of Rahul Narvekar was proposed by the BJP MLA and the name of Ranjan Prabhar Salvi was proposed by Shivsena. So, Mullah, this Rahul Narvekar was proposed by a BJP MLA because he happened to be a member of the BJP. Then, 2nd of July, Sunil Prabhu, acting as Chief Whip, issued a whip. Now, Mullah, till that day, Sunil Prabhu is still the whip. Acting as Chief Whip of SSLP, issued whip to the members of SSLP regarding the election of the Speaker, scheduled on 3rd of July. All the party members were asked to remain present in the assembly and vote for the Shivsena candidate, Rajan Salvi. Sunil Prabhu issued a further whip to the members of SSLP regarding confidence motion, scheduled on 4th of July. All the party members were asked to remain present in the assembly until the end of the session and vote against the confidence motion. Well, as your lordships must just keep one thing in mind. It's not their case that they merged with any party. It's their case that they belong to the Shivsena. So if they belong to the Shivsena, then how can they disobey the whip? And vote for a BJP candidate against the Shivsena member? There is no evidence required here, Maharaj. Then on 3rd of July, Ajay Chaudhary, acting as the leader of the SSLP, submitted a letter to the Deputy Speaker requesting him to conduct the election of the Speaker of the Legislative Assembly by division of votes. Ajay Chaudhary on the 3rd of July submitted a letter to the Deputy Speaker requesting that the votes cast by the members of the Legislative Assembly who have incurred disqualification should not be considered during the election of the Speaker. 3rd of July, the election for the office of the Speaker of Maharashtra Legislative Assembly was held. Rahul Narvekar, the candidate for the Bharatiya Janata Party, was unconstitutionally elected as the Speaker of the Maharashtra Legislative Assembly after getting a total of 164 votes. During the elections, it was recorded by the Deputy Speaker that 39 delinquent MLAs of Shivsena Legislative Party, led by Eknath Shinde, had voted against the party whip. Now, at this point in time, there is no other whip. Now you will see on the evening of the 3rd, after
How many votes did the rival candidate poll that day?
Sorry?
Of July. How many votes did the rival candidate poll on the 3rd of July? Speaker.
That's all. We are not mullahs on majority minority. Yes, that's correct. I'm glad that my learned friend pointed it out, mullahs. Correct.
But therefore, if these 39 are excluded from 164,
Mullahs,
they still have 125.
I am not mullahs on that. I'm only saying that they voted against the whip, therefore they are deemed to be disqualified. That's all I'm saying, mullahs. I'm not saying, mullahs, whether he would have. Supposing, mullahs, all of them are disqualified, because on that particular day they voted against the whip.
These 39.
All 39.
No, but therefore, if you exclude these 39
Yes.
from the 164,
Yes.
they're still down to, they still get 125, right?
That's right.
The fact
Your lordship is right, mullahs. I am at the moment, mullahs, I am not challenging. At the moment, mullahs.
Because this comes soon on the heels of the trust vote, which takes place on the 30th.
Yes.
So this is now an indicator within 3 days.
Trust vote happened on the 4th.
Because Mr. Sibal,
Trust
you
vote
don't
happen on the 30th, mullahs.
right. You don't ultimately you don't face the trust vote.
Yeah, I don't, mullahs. So therefore, it is held on the 4th. And we challenge the trust vote also. We've challenged all decisions, the election of the Speaker, trust vote, whatever. All that is challenged. Mullahs, the question is, at the moment, mullahs, we are dealing very, very limited issue. One, should the courts have given time?
That's a separate issue because it's an order which is an interim order.
Yeah, it's an interim order. What was the result of that, mullahs? That these people were able to topple the government without the disqualification petitions having been decided. There was an elected government, mullahs, which was in power. The 10th schedule was used for the purposes of toppling an elected government. And supposing tomorrow, mullahs, your lordship holds by these actions, which are uncontroverted, that they disqualified themselves on both counts, 2(1)A and 2(1)B. What will be the result? And if your lordship holds otherwise, let's assume against me, then this will be, mullahs, You have given them a model to topple every elected government.
Mr. Sibbal, are we not still down to, if you are really looking at the numbers here, are we not down to the situation where the speaker's election at least indicates that because 38 was sought to be disqualified, there were disqualification petitions against the 38. Now, if you exclude the 38 for a moment from the 164 who voted in favor of the resolution for the speaker, you still have a situation where that's in very close proximity to the date on which the trust vote was to be held on the 30th.
Yes,
Now, you resign, right, on the 30th.
yes.
And therefore, is this not really clearly an indicator that even excluding these 39?
That's all right. The speaker could have been Manoj. Yes, I'm not disputing that, Manoj. I'm not sure what the arithmetic is.
Manoj, what my Lord
Half
Chief
145 is the halfway mark, Manoj.
Manoj, what my Lord the Chief Justice
You
asked.
deduct 34, you are below, Manoj. I'm sorry. In fact, the arithmetic is the other way.
No, my Lord, 288 was the total.
Yeah, just
What's
let's-
the number?
Just give it,
288
We'll just
was
give you
total
the
strength of the assembly.
Mr.
The
Paul.
actual,
just 1 second.
yes,
Total strength of the assembly,
288.
that was there from Mr. Sibbal's chart, which we
Right.
saw.
Actual votes received by Mr. Narvekar were 164, which is over the 50% mark of 144.
Just 1 second, just one second. Total
So
strength
the
of the
half
assembly.
mark would be 145.
Just a
1 second.
yes.
164.
So if 144 is the halfway mark, 145, 164 votes were received by Mr. Narvekar if the strength was taken to be 288. If 39 MLAs are excluded from the strength of the Legislative Assembly, the effective strength comes down to 249.
249.
And out of those,
Just 1 second.
249, half of it is
249 and then.
and the effective votes received by Mr. Narvekar were 125, which is over 50% of the votes required. So under any circumstance,
Effective
even if 39 MLAs are removed,
Plus, there were only 16 disqualifications.
yes, plus on